All right, so today's discussion, wrapping up our series for the month, today's discussion is the as is contract review, right? And so the this today's discussion, of course, because of the time that we allocate to our meetings on Thursdays, it's fairly high level. It's going to assume that you've taken a contract class before, right? It's going to assume that you've taken a contract class before. Many of you probably have set in on my 3 hour contract classes. I have not done one this year yet before. We'll get one on the calendar. But this assumes that you've taken the contract class before. If you've not taken the contract class before, then definitely keep an eye out. You should be taking a class that goes over the as is purchase and sale contract. Not necessarily line by line, right? We don't say line by line because literally that would take a whole day at least, but at least section by section. But you yourself should take the contract and review it yourself during your time, line by line. I've mentioned to some of you guys before that my first introduction to the purchase and sale contract, when I moved back to Florida from California, and I was starting in real estate in Florida, even as an attorney. I mean, he said, I learned the contract, put the contract in front of me, and sent me in the conference room. He was like, here you go. Like, all right, all 13 pages, huh? And so, even as an attorney, you don't want to have to read 13 pages, right? But I'll tell you guys that you should read through the 13 pages. But not only that, you definitely want to put yourself in a position to get context around these 13 pages, right? And so that's what a 3 hour class will do for you, as well as doing deals, as well as every time there's a conversation about the contract, you need to be a part of that conversation. Because, yes, this is the verbiage is here, but what does it look like in application, right? What does it mean when it's time to actually execute on the terms of the contract? And so that's what we're going to talk about today, as we talk about what this looks like in action. All right. All right. So we got a lot of a lot of new faces. So I always, every week I tell you guys, I do not want to assume that that everybody knows, because we have many familiar faces. A lot of us, many of us, most of us meet here every Thursday at 12 o'clock. But there are some who are new to the gang. And so I want to make a formal introduction so that so no one feels, like they don't feel welcome. Right. So we'll make sure we welcome everyone. So for those who I have not had an opportunity to meet before, my name is Ray Cole Jackson. I'm a South Florida real estate attorney. A little about me personally, my background professionally, how I got here. I attended the University of Florida for undergrad. I always say go Gators. I went on to Santa Clara University School of Law, where I attended law school, and I was the founder of the Real Estate Law Society. I've always had an interest in real estate, always loved real estate, but was the founder of the Real Estate Law Society there. Came back home and got my LLM in real property development from the University of Miami School of Law. So go Canes secondarily. I'm a proud licensed Florida realtor. I got my first real estate license in California during law school, where I did real estate out there. Came back home and got my license in Florida. And I'm also a licensed loan originator in Florida. I got my first loan originator's license in Florida before law school. And so I've held those licenses for a good amount of time now. So professionally, I own and operate a real estate law firm, title company, mortgage brokerage, and real estate brokerage, right? And so when we come together on these conversations each week, the purpose is to ensure that you guys, we can have a 360-degree conversation, right? And so whatever the question is, however however it's presented, we can talk about it, right? All right. So again, so for those who we not met before, I've not met before, nice to meet you. Welcome to Thursdays and welcome to the lab on Thursdays. And we hope to see you each week, same place, same time. Our handout for today, go ahead and grab it. PurchaseReadyLabHandout.com. Grab our handout for today at PurchaseReadyLabHandout.com, or you can use the QR code. If you're on the desktop, you can use the QR code. All right. All right. So today's discussion, a roadmap. What I want you guys to think about as you learn the purchase and sale contract, and you digest the the substance of it, I want you, when you go to make an offer, review an offer, just realize that it's a roadmap, that it does not change for the most part. Meaning, obviously, we know that we have updates, but when I teach you the contract class, one of the things I tell you is that 90% of the contract is static. It does not change, right? 90% of this is just not going to change. Only 10% of it is changing based upon your transaction, right? And so what is that? That's your parties, that's of course the property, that is the personal property, the purchase price, those terms where you see blanks, right? But you guys have the handout now. But if you flip through this contract, once you get past page 1, you start just seeing a lot of just text, and definitely page 5 all the way to page, oh my God, to page 11. All the way to page 11 is text. That's not going to change. And so your responsibility is to know that text, right? Understand it. But as it relates to reviewing an offer and a contract, what we're specifically talking about today, you really have to hone in on the hot spots, because that's the portion of the contract that changes based on your transaction, right? And so that's what we're going to look at today. And that's what we're going to get a framework around. How do I review an offer when it comes in to make sure that I'm not missing anything, right? Because just because you miss a section doesn't mean that enforcement of it goes away, because it does not. All right. Um, One of the things you see here, you never want to leave a blank. So if you look at the contract and you run your eye down the left side, one thing that I love about the purchase and sale contract, number one, is that it's numbered, right? So it's easy to tell you, um, go to line 15 instead of saying, or line 16, instead of saying the second line after subparagraph D in the personal property paragraph, I can just say line 16. I love it. Every line is numbered. In addition to that, where there are sections in the contract where you need to fill in information or select one of the options, if there's multiple options, there's an asterisk next to the number. Love it. So when you are making an offer and reviewing an offer, here's what you need to do. You need to make sure that you run your eye down the contract. Wherever you see an asterisk, you need to go in and make sure that you filled in the information, because hint, those asterisks are your hotspots, essentially, right? All right. So that's the first checkpoint, making sure that when I believe that I've completed my offer or I've completed review of the offer, I've taken my eye down and reviewed every line where there's an asterisk, filled in the information, or select NA. There's no reason to leave blanks, guys. There is no reason to leave a blank in your contract. No reason. All right. Either it applies or it doesn't, right? Either you've agreed to the term or you have not. And if you have not, NA, right? All right. So that's the first point. 90% of the contract is static. Learn it. It's not going to change. 10% is what's your hotspots, because it is going to change. It's transaction specific. Make sure that you run your eye down the line. Wherever you see an asterisk, make sure that you either make a selection or not leave a blank. All right. All right. Another background bit of information, because I don't want to assume that anybody knows this, because we have different levels of experience, right? We know that there are two standard forms of contract that we use in Florida on the residential purchase and sale side, right? We know that we use the contract for residential sale and purchase. That acronym is CRISP. That's the CRISP. And then we know that we have the as is. The difference between the CRISP and the as is, let's hit those really quickly. The CRISP is it starts out from the position of the seller agreeing to make repairs to the property at a specific dollar amount, versus the as is, the property the transaction starts out from an as is position, seller's not agreeing to make any repairs to the property. Of course, there later on, we know that as a matter of custom, we always negotiate for some repairs to be made or credits for repairs. But know that as a starting point, the as is starts from a place of you're purchasing the property as is buyer. I'm not making any repairs. I'm not paying for any repairs. All right. Repairs are built into the initial term of the CRISP. Again, no initial repairs required, although they are customarily negotiated later, right? After the or during the inspection period. The CRISP is very rarely used in transactions nowadays. I can't tell you the last time I've gotten a CRISP in my office for closing. It just does not happen. I mean, at this point, we're almost 100%. We use the term, I use 99% because, of course, I don't get every contract. And of course, there's always a chance that someone could use a Chris, but 99.9% of the time, it is an as is contract. All right. And so you want to make sure that you know that as a professional, that there are two standard forms of contracts in Florida, your CRISP and your as is. Your as is most customarily utilized. All right. Now, the last thing is you want to make sure that you verify the version of the contract that you're using. If you take your eye down to the very bottom of the contract, you'll see that there is a um, revision, right? So it says REV period, and then ours is 2-26 because we just had a revision made to our as is purchase and sale contract for what? For Benson, which you guys be getting an email. If you have not heard already, that's paused again. Um, due to a challenge to that rule. So fencing, you know it now. The rules of it, the substance of it, we'll see if it changes. But as of right now, it's on pause. It's not being enforced due to a recent challenge to the law. But in any event, our as-is contract was updated in February 2026 for that legislation, and it's still in there. Although you will not see it enforced, you should not see closing agents collecting that information that we were required to collect when fencing was enforced. All right, all right. So let's look at the contract itself. And again, we're going to go section by section. And I want to call out some hot spots for you. As you are, again, we're looking at this from a perspective of preparing an offer and reviewing an offer. And another thing I want to say is because again, we're in a learning environment, right? The reason why I'm using the term offer is because you don't have a contract until it's signed by both parties, right? So we want to make sure that we use the appropriate terminology. Is it going to kill anything? No, but we're being professional. This is an offer, right? It's an offer. So you want to grab Susan, you could grab the contract if you go to the handout. PurchaseReadyLabHandout.com has the contract in there. For those of you who have downloaded the handout, you do have the contract, yes? Okay, perfect. Thank you. So Susan, go to purchasereadylabhandout.com. Thanks, Jessica. And you'll see the contract there. There'll be a couple, there's three parts to that handout that you'll get. All right? All right. So let's start at the first section. The parties. I get this question often. Thank you guys for confirming. If your seller is an individual, of course, you want to, first of all, you want to make sure that you fill in the parties according to what is indicated on public records, right? So the appraiser's office, tax assessor's office, whichever one of those government sites that you use, you want to make sure that that's who that's who's signing. Now, of course, if you represent the seller, you would have already verified this at the listing stage, right? You're making sure that your listing agreement is signed by the individual who owns the property, who has the authority to sell. All right. And then, of course, when you're making an offer, as a buyer's agent, you're going to check public records and you'll make sure that you fill in what is indicated as the seller. As it relates to individuals, if your seller, if one of your sellers, if they hold title individually, but they're married, that spouse must still sign the deed at closing if it's a homestead property, even if they're not on title, right? All right. So John Doe, Jane Doe. John Doe bought the property. No, Jane Doe purchased the property when she was single, right? And so it shows Jane Carey. I don't know. So Jane Carey, right? So on the contract, she's Jane Doe, or even when we I'll give you a back view at title, it's actually going to say Jane Carey, now known as Jane Doe, right? And because she's married and she's indicated that this is her husband, John Doe has to sign as well. It's important that you know that, right? Even if an individual is married and they're the only one on title, if it is their homestead property, their spouse must sign the deed. So know that, right? And then we go on. If the title is held by an LLC, we're looking for a manager to sign. If title is held by a corporation, we're looking for a president or vice president to sign. If title is held by a trust, we're looking for a trustee to sign. If title is held by an estate, which they don't really hold title, we know that an estate is an entity that is created by as a matter of law as soon as an individual passes away. As soon as an individual passes away, as a matter of law, an estate is created. And what happens with the estate now has the interest in whatever that the decedent owns. And what happens with the estate is now we have to go to probate to administer the estate, where we determine who now owns whatever assets are part of the estate res, we call it, right? So a property can be sold before an estate is settled, before probate is completed. At that point, we're going to be working with a personal representative, right? The court is going to appoint a personal representative, but then they're also going to, during the pendency of an estate administration, we can get a court order to sell. And in that order to sell, they're going to already have also determined who needs to sign the deed. It could be the personal representative. They could have already determined who the heirs are, right? But for your purpose, we do get, and you will get, you can take a listing where the property is in probate and the probate hasn't been completed. You can take a listing. You can take a listing, and the personal representative is going to be your contact. All right. All right. So that's your parties. Your property. Of course, easy part is the address, county, tax ID, we take that from public records. The legal description, we take that from public records. Your legal description can be the short legal description. By the time we get to closing, we'll add in the closing team will add in the full legal description, right? What I want to make sure that I touch on is personal property. The property that's going to convey at closing. This is important. This is important from a buyer's perspective. We want to make sure that their expectations are accurate. And we want to make sure that the seller's expectations are accurate. Okay? So I want to read this line by line because this can create disputes. So we'll start at line 9. So subparagraph C. The legal description is, so legal description of the property, together with all existing improvements and fixtures, including built-in appliances, built-in furnishings, and attached wall-to-wall carpeting and flooring. Yes, we have to, you'd be surprised, you have to literally say that. Unless specifically excluded in paragraph 1E or by other terms of this contract. Then we go on to subparagraph D. Guys, do not blow over this. Within this past month, we've had at least 3 closings where there's been an issue with personal property, right? So, paragraph D, unless excluded in paragraph 1E or by other terms of this contract, meaning if you put it in the additional term section or an addendum, the following items which are owned by the seller by seller and existing on the property as of the date of the initial offer. Meaning, Joanne takes the buyer to view Vicious listing. If there are chandeliers in every room when she makes that offer, her buyer expects those chandeliers to be in every room at closing. That means his seller cannot, the day after they receive the offer, unless they update the contract accordingly, you can't snatch out the chandeliers. It's as of the date of the offer. When I made an offer based upon how I saw that property at the time. Is that clear? All right. You can't change it. If the seller makes change to the property, removes items, then they have to make sure that the contract is updated accordingly to exclude any items that they've removed. All right. They are included in the purchase. The range oven, we know that it doesn't say microwave, so you will go ahead and want to say microwave, but it includes built-in appliances. If that microwave is built in, we expect that to remain. If it's on the counter, that's different, but that's a built-in appliance, right? Refrigerators, dishwashers, disposals, ceiling fans, light fixtures, drapery rods and draperies, blinds, window treatments, smoke detectors, garage door openers, thermostats, Nest, doorbells, Ring, television wall mounts, and television mounting hardware, security gate and other access devices, mailboxes, and storm shutters, storm protection items, and hardware. Other personal property items included in the purchase are what? We know this section is for our washer and dryer. For whatever reason, it's not still a standard item, personal property item that's included in paragraph 1D. So if it's going to be included in the sale, then you need to make sure that it's going to be added at line 21. At line 21, you want to make sure that you describe the washer and dryer. So you don't necessarily have to put the model number unless it's very exclusive, but stainless steel AG front load washer and dryer. I will be specific because there have been situations where washers and dryers were switched out. One agent told me the front doors were switched out. I was like, oh my God, I've never expected that. But it doesn't hurt to be specific. Again, model number, you can. It doesn't hurt, but you don't have to crawl behind someone's machine looking for a model number, right? But the washer and dryer needs to be included. Now, let's be clear. If there's not a washer and dryer at the property when you view it, you writing that in is not going to change anything. You're not going to all of a sudden create a situation where the seller needs to buy you a washer and dryer. If that's what your expectation is, now you can't agree to that, but if that's your expectation, then you need to be very clear that seller will credit the buyer for a washer and dryer, right? But notice that it says line 16, which are owned by seller and existing on the property as of the date of the offer. All right. Going back to the same hypothetical. Let's say, for example, for whatever reason, Vicious's seller is having an event, they want to go out with a bang. And so they install chandeliers for this going away dinner party. Well, those chandeliers were not there when you toured the property. They were not there when you made your offer. So you cannot expect those chandeliers to be there when you conduct your walkthrough. I'll even put more meat on the bones. No chandeliers. You go under contract. Vicious is prepared. Vicious. You got a 10-day close. Vicious seller is like, yes, I want to do my last dinner party though. So they put up chandeliers. Your buyer does an inspection. They see chandeliers. They're like, oh, we have chandeliers now. No, you don't. They're going to take those chandeliers down and put the ceiling fans or whatever were there when you did your tour, and you made an offer. That can happen. Okay. Now those nuances make sense because now you understand the contract, right? You can navigate a discussion about that because you understand the contract. All right. All right. What needs to be excluded? Paragraph 1E. So Trying to think how to give you guys a scenario without being too clear. Um, you can have personal property that is attached to the property, not a fixture, and it's not coming with the property. Um, I'll use an example. Air freshener. It is what it is. So had a transaction. Seller had an air freshener that was screwed into the wall. Buyer expected that air freshener to stay there. That's personal property. Did a walkthrough. Buyer says, where's the air freshener? Where's the air freshener? Where are the chargers that were in the garage? That's personal property, right? That's not coming back. That's personal property. And so um, these types of nuances as we, going more and more to the modern era. Like for example, the thermostat and the doorbell. We didn't have Nest and Ring back, you know, years ago, but now it's a common thing and it's important to the property. So now the contract is updated for that. Will we eventually see the contract updated for other items? I'm sure we will. But I just wanted to give you guys an example of those are some modern day personal property items that when you do your walkthrough as a listing agent, point it out. If that's not going, it's not going. You need to make sure that I would even include it in the MLS. Of course, the MLS is not binding, but just so that we're not even having a conversation. And you can include it in the contract. So we're not even having a conversation about these chargers that are installed in the garage. That's coming with the seller. So we're not having a conversation about this air freshener. There's some expensive air fresheners. I think this unit was like $800, but it's personal property, right? So this is important for us to know when we are making offers on a property. Okay. All right. Dropping down to paragraph 2, talking about the money. Um, what I want to make sure you guys are clear on is, obviously your purchase price. That's not an issue, but the deposits. I get questions oftentimes about the deposit. Line 28 is your initial deposit. What is that amount? If line 30, um, where you select will be made and you leave it blank, if you leave that blank, it's going to be within 3 days, that initial deposit is going to be made. The additional deposit is where there's some confusion. That additional deposit is from the effective date, not from the date of the initial deposit. All right. So line 36, additional deposit to be delivered to escrow agent within, if left blank, 10 days. After effective date will be, what is that number? Again, that is after the effective date, not 10 days after the initial deposit is made. So even if the initial deposit is not made for 7 days, that if you agree to an additional deposit, unless you change that date, you're going to be making that additional deposit in 3 days because the additional deposit is 10 days from the effective date. All right. So let's be clear on that. That additional deposit is from the effective date, not after the initial deposit is made. Now, if you intend to create some space between the initial deposit and the additional deposit, you can do that, but you need to just fill it in, right? You need to not leave it blank. Again, don't leave blanks. All right. And then lastly, the balance to close, line 41. Um, Practice point for you in case it comes up with a buyer, that's expected to be a wire. It says it there in the contract. Line 41, balance to close, not including buyer's closing costs, prepays, and prorations by wire. By wire. That's in the contract. That's not a closing agent. The closing agent is going to require it as well, but that's by agreement in your contract. It is by wire. Okay. Lastly, missing deposit is a breach. It's a breach. It's a breach. It's a breach. It's a breach. Um, can the seller waive your breach and accept your deposit later? Sure. But you should know that that is a breach. Um, you should get an escrow letter same day as deposit, depending upon when the deposit is made. But uh, you're not getting an escrow letter to the seller on the day that the deposit is due, even though the deposit has been made, is not a breach. Someone's saying like, Rico, duh. Well, listen, I've had to deal with that dispute before. So know that the escrow agent getting you the escrow letter for whatever reason, the day after the escrow deposit is due, that is not a breach on the buyer's part. The buyer's duty was to get the funds in, not to get you an escrow letter. Okay. Now, similarly, it is not the escrow agent's responsibility to track down an escrow deposit. Meaning they're not going, if they send the wire instructions, they're not chasing down that buyer and say, hey, Cassandra, it's 4:15 and today's the deadline for you to get your escrow deposit in. That's not the closing agent's responsibility. All right. So know that. All right. Dropping down to paragraph 3, time for acceptance and effective date. This is probably the hottest section outside of financing in the contract. We have to know how to calculate time and how to calculate our deadlines. This is important for contract review because if you accept an offer, and I've still seen contracts, not very often, but if you accept an offer, let's say for example, going back to leaving blank, where you allow line 69 to be left blank, the buyer now has 30 days to get their loan approval, but you were expected to close in 21 days, we got a problem, right? Now, this whole 21 days is a financing contingency period, meaning that the buyer can cancel all the way up to closing date because we did not take the time to review our timeline when we were reviewing the offer that was sent to us. This is very important. Again, I don't see it as often as I used to, but every now and again, you see a contract where the seller has allowed the financing contingency, the loan approval deadline to be left blank. And so that they have a 30-day loan approval deadline. You don't want that. All right. So let's review paragraph 3 really quickly so that we are clear on number 1, how do we determine our effective date? So we're looking at 3B. And let's go ahead. 3A, you guys know that's your deadline for the buyer, I'm sorry, for the seller to accept the buyer's offer. If the seller does not accept the buyer's offer by that date, then the offer is expired, right? They move along. They don't have to do anything to notify the seller the offer is expired. But here's what's important for the purposes of today's conversation. Paragraph 3B, starting at line 48. The effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed and delivered this offer or final counter offer. That is your effective date. That is your effective date. The effective date serves as day 0. So signature plus delivery is equals your effective date. Signature plus delivery is your effective date. Whenever I get questions from agents on confirming their calculation of a time period, I ask for their delivery date. I don't even ask for when it was signed because this is most important. Yes, we have a fully executed contract here, but it is not, we don't start counting until it's delivered. Are we clear on that? Delivery.
How how determine delivery date?
Oh, right here. Good question. Because there's nowhere in the contract for you to confirm the delivery date, we see the signature date. Best practice is for the agent who's either delivering or receiving to
To
confirm in an email.
There you go.
There you go. Good question, Peter. All right. So you're going to always confirm in an email. Confirming receipt, July 24th is our effective date. See you at the closing table. All right.
I like to take it a step further and have a confirmation of all of our critical dates to the other agent so we both know what that we're both on the same page.
Oh, 100%. That's the next class. So yeah, we've exhausted for those we've had classes on that. That's our anatomy of a transaction where we have a whole contract abstract. We have a form, and I'll definitely make sure that we get that shared out again, where you would lay out your dates to make sure that this offer is in line with what you're expecting. So yeah, and so that's the thing too. I'm glad Peter brought that up. Oftentimes, or most often, 99% of the time, that's done after you've already gone under contract. That's not the case. That should be done when you are making the offer and accepting the offer. Because guess what? If the listing agent had done that, guess what you avoid? What I just told you about, agreeing to an offer where, accepting an offer where the financing contingency is past your deadline. Or what about if it's not even passed? What about if it's right before it's the day before closing? It can happen, right? So you want to make sure that your financing contingency, for example, you give yourself some room. I don't want to find out a day, 2 days, not even 5 days before. I want to know ASAP. I want to know within 10 days, 7, 10 days of closing, whether or not you got your loan approval, right? And you can be aggressive like that. We talked about that before. A very well underwritten file, you can be aggressive about those timelines, all right? So, again, for the purposes of paragraph 3B, we know that our effective date is signature plus delivery, and the effective date is day zero. Day zero. Now, attached to paragraph 3 is paragraph 18F because it defines for us it gives us a definition of time, and it gives us how we count using calendar days. It also tells us that it's calendar days. So let's just bounce forward really quickly to paragraph 18F. So paragraph 3B and 18F go together. So first of all, time is of the essence. What does that mean? I'm going to go back to our prior slide. Time is of the essence means this is a strict standard with zero grace period for illness or delay. I had an agent one time say to me, well, what about if my buyer was sick? Communicate. That doesn't change your deadline. All right? Communicate. Now we have built-in extensions. We know about force majeure, right? Hurricane, acts of God. We have some built-in extensions, but being sick is not one of them, right? Because we have the ability to reach out and get an extension on whatever particular deadline we are facing. All right? So, paragraph 18F. This, you guys need to highlight this, know this like the back of your hand. Time. Time is of the essence. We just talked about that. Calendar days. Oftentimes we get the question, is it calendar days or business days? 18F tells you calendar days we use in the as-is contract based on where the property is located is used in computing time periods. Calendar days is used in computing time periods. What does that mean? That means that you count every day when you're getting to your deadline, including holidays. You don't skip holidays or weekends, right? You count every calendar day until you hit your deadline. Now, when you hit your deadline, there are instructions on how to address that to determine whether or not that is in fact your deadline, right? So, which is line 431. Other than time for acceptance and effective date, paragraph 3, remember we said they go together. Other than those deadlines, as set forth in paragraph 3, any time periods provided for or date specified in this contract, whether pre-printed, handwritten, typewritten, or inserted herein, which shall end or occur on a Saturday, Sunday, National Legal Public Holiday as defined by the U.S. Code, or a day on which a National Legal Public Holiday is observed because it fell on a Saturday or Sunday, shall be extended to the next calendar day. So what I just tell you, I said the first thing is you're going to count every day. And then it goes on to say, Now, if that deadline falls on a Saturday, a Sunday, a holiday, or a day on which a holiday is observed, now you're rolling forward to the next calendar day, which is not the next calendar day, which is not a Saturday, Sunday, holiday, or a day on which a holiday is observed. That's about 3 lines to tell you that. Are we clear? Right? So that's saying, other than time for acceptance, line 45, and the effective date, line 48, whatever that date is, that's the date. You don't roll forward. Whatever that date is, that's the date. You don't roll forward, right? So Candace representing the seller, seller gets the offer on a Saturday. I'm sorry, on a Friday. They take their time to review it. Okay, great. They get it back to Candace. Candace is already asleep. She sends it back to the buyer's agent on Saturday. The effective date is Saturday. We do not roll that forward. Okay? All right. Time for acceptance and effective date are fixed. They do not roll forward. Are we clear on that? Yeah? Clear as mud? Clear as mud. Here's an example. Here's a visual. Um, Cynthia, she represents the buyer. Candice represents the seller. Her buyer makes an offer on the 10th. Kansas is all over it. Seller gets it. Seller accepts it on the 10th, delivers it back to Cynthia on the 10th. Our effective date is the 10th. Offer made on the 10th. Accepted on the 10th. Again, it was late. So Candace doesn't get it back until the next day. Our effective date is the next day, the 11th. It's the date of delivery, not the date that it's signed, right? Let's say Candace is real busy. She just had a very good weekend, right? So she gets it. She gets it on the Friday. Seller accepts the offer. For whatever reason, Candace is traveling. She doesn't get it back to Cynthia until Monday morning. The effective date is Monday.
Question.
Answer. Go ahead.
Do we have to get confirmation from the person that we sent that from the, other side that we've sent the email that they've received the email?
I get that question often. Do you have to get confirmation? No. But why wouldn't you? Right?
It's- Some people just don't check their email.
No, no,
Uh,
no, I get that. But now you're at the point, if you, let's say for example, you are the buyer's agent and you have a executed contract. What's your next step? You're scheduling what? Inspection. Hey. So my point is there's just various reasons to have a conversation that you should
right. I agree.
invariably.
I agree.
Yeah. And again, that's why we have these conversations because technically you do not have to confirm receipt. You only have to confirm delivery, right? You only have to be able to verify delivery.
Okay.
Um, However, just by virtue of completing your next task, you were going to have a conversation, right?
Right. Right.
Yeah. But that's a
So
good question.
some people don't some people don't turn on their phone on Saturday, for example. So if I'm receiving an executed contract and it comes on Saturday, chances are I would not get it until maybe Sunday.
It doesn't change the effective date.
Effective is still Saturday.
That's right.
Okay, because
Shane,
that's
good
the
to see
delivery
you.
date. Hmm.
Her page just popped up. Um, yes, it does not change it. It does not change your effective date. It doesn't change your effective date. Um, I was gonna say something and I lost my train of thought, but it would come back to me. Um, but yeah, it doesn't change your effective date. Um, and separate conversation, you just have to have um a framework around that. If you know you don't have your phone on Saturdays, but Saturday is a day that you know you could be doing business, um, you got to put something or put a framework around that. Is somebody else keeping an eye on it? But I mean, let's if Saturdays are not, even if you don't have your phone up on a Saturday, it's not like Saturday's a business day per se. So let's say, for example, it's not like it's not a Monday where you did not receive the executed contract. Now you didn't get the contract, the title can't get wire instructions out. You get what I'm saying? So there's not a ton of things that are happening over the weekend that should you miss receipt of it, it will be totally detrimental. Now you're gonna lose some days depending upon who you represent, but those are just some things to think about in that regard. All right. All right. All right. Moving along. So paragraph 6, we've gotten past some of the meatier part of it, particularly time. Let's talk about the other sections that we need to be sure that we basically have things to do, right? Pursuant to each transaction. Paragraph 6, occupancy. If you know that there's going to be tenants in that property post closing, guys, please make sure that you get leases. If there's no written lease, at least an estoppel, because your buyer is going to step into the shoes of the seller, and they are responsible for maintaining status quo with that tenant until that tenant must vacate the property. All right. So never inherit a tenant without a signed estoppel. Right. It's going to lock in the exact terms, the security deposit amount. What if you have a tenant, the you don't have anything documented, tenant gets ready to move out, and the seller told you that it was $5,000 in escrow deposit. The tenant said, "Excuse me, it's 10, but you don't have anything in writing from the tenant." We have a problem. So guys, do not, you got to make sure that you use much care and diligence when you know that your buyer is purchasing a property that's going to have third parties remaining in the property after closing. This is not seller post-closing occupancy. This is tenant post-closing occupancy. The contract deals with tenant post-closing occupancy or third-party post-closing occupancy, because it could also be a short-term rental like an Airbnb. Those folks are not tenants, but they're third parties. The contract deals with third-party post-closing occupancy. If you're going to have a seller post-closing occupancy, then you're going to use the appropriate writer. Um, and then when we get to writers, I want to give you guys some notes on that too. The terms of the seller's post-closing occupancy, you need to iron that out. I've seen numerous times where now the parties are under contract, they have not ironed out the terms of post-closing occupancy, and someone feels slighted. Either the seller feels slighted because the tenant is asked, the new buyer is asking for more than they want to pay, or the buyer feels slighted because the seller is not willing to pay as much as they would like. You get what I'm saying? So if you know that you're gonna have a post, if you going in, you know that you're gonna have a post closing occupancy scenario, I recommend that you iron those terms out at the offer negotiation stage. All right. Closing costs. We're gonna hit a slide on that really quickly. Have a handout in the I have a page and a handout for you. Know that closing costs, when you get to paragraph 9, that is fully negotiable. Who selects a closing agent? Paragraph 9C1, 9C2, and 9C3. That's we have what's customary, and the handout shows you what's customary, and I have that graphic on a slide too. But know that it doesn't have to be the buyer in Miami-Dade County because they're in Miami-Dade County. It could be the seller. Similarly, it doesn't have to be the seller in Palm Beach, because customarily the seller selects the closing agent. But that's all negotiable. We have customs, but then we have what's negotiable. Jane, go to purchaserelabhandout.com. Purchaserelabhandout.com. All right. Disclosures. We talked about disclosures the week before. or last week. You want to make sure that you have all your disclosures as we move forward. Okay. So really quickly, let's look at paragraph 8. You're welcome. Let's look at paragraph 8. This is the second hotspot. Outside of time, this is the second hotspot. If you have a financed transaction, guys, you have to be clear on paragraph 8, including what? What is my loan approval debt? Oh, went too far. What is my loan approval deadline? If you represent the buyer, you have to be clear on what is your loan approval deadline because you have some obligations. You must notify the buyer in writing, I'm sorry, the seller in writing of the status of your loan approval. Of course, if you are not approved, you need to let the buyer know because you're either going to cancel or you're going to be asking for an extension of the loan approval if they agree to it. Or you guys always know the hypothetical I use. You may say your lender is Superman and I'm not approved yet, but he said he could do it, so we're proceeding, right? Or we're approved and we're proceeding, right? But one way or the other, the contract provides in paragraph 8 that you're supposed to provide the seller written notice of the status of your loan approval by the deadline that you agree to. Of course, we're in a different market, but you should know what's in the contract. What's in the contract is if the seller is not provided a written notice of the buyer's loan approval by the deadline, the seller has a 3-day window to unilaterally cancel this contract. Someone's saying, why would it cancel? Why would the seller want to cancel? Maybe they've been trying to get out of it anyway. They changed their mind, right? Or the example I commonly use before was when, like during COVID, when the value of properties were just going up, going up, going up, right? We're in a contract for 500,000. My neighbor just closed for $1 million. Get me out of this contract, Jane. Now, of course, we know that there are very few outs for a seller once they're under contract, but this is one. If the buyer fails to give written notice of their loan approval status on a finance transaction, know your contract. Know your contract. Also, the appraisal. If the buyer's financed and loan appraisal is a condition of their loan approval, that needs to be completed by the loan approval deadline. um it's over a year ago now. There was a loophole where the buyer could have gotten the appraisal after the loan approval deadline and said, oh, property didn't appraise, I need to cancel. That loophole is gone. If the financing is contingent on an appraisal, that needs to happen by the loan approval deadline. The last thing I want to say, guys, don't mess this up. You're going to get, the lender is going to send at the loan approval deadline, most will send a conditional loan approval document. And their document says a conditional loan approval. It says your loan is approved, condition on these items, these last few items. Guys, a conditional loan approval does not extend your loan approval deadline. A conditional loan approval from the lender, it's a standard document, but it does not automatically extend your loan approval deadline that's indicated in the contract. Are we clear on that? I've literally had lenders ask me, well, I sent the conditional loan approval. Okay, that secures you. That secures your agreement with the buyer that this is not a full out approval that is conditional, but it does not create another contingency in this contract. If your buyer goes past his loan approval period deadline based upon a conditional loan approval, which every buyer gets a conditional loan approval, and then they ultimately are not approved, you cannot unilaterally cancel this contract and say, oh, the lender didn't approve us, but this condition was on the conditional loan approval. Are we clear on that? Like, I literally had a lender that said, but I gave a conditional loan approval. That's for you. It's not for this contract. So guys, don't miss that.
I
Okay?
never had anything else other than that conditional loan approval. So I'm
Correct.
supposed to receive another
No,
letter?
no, no. No, good question. You are going to receive that. That's a standard document provided to the
Mm-hmm.
buyer
Mm-hmm.
during the lender's underwriting process. But what you need to understand is that document, although it says conditional loan approval across the top, that does not create a contingency for you past the loan approval deadline.
So what do I need to provide to the listing agent as far as
If
that?
you need to cancel,
No, 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 no. I'm
well, that's
supposed
the
to.
point. No, no, no. You don't need to. This is talking about cancellation. This conversation is
Oh,
about
okay. It's for
right. This
cancellation
conversation is about
purposes.
cancellation.
Okay.
The first point to know is pursuant to paragraph 8, you have a deadline to obtain loan approval. Of course, it's going to be conditional. Let me use the appropriate term. It's going to be a conditional loan approval from the lender because they're going to have some very final checks that they do, make sure they still have a job, make sure their credit is still intact before they give the full loan approval, right? So by the date indicated in paragraph 8, you're looking at a conditional loan approval from the lender. What I'm saying to you is great. That's what you want. You want to notify the seller that you have a conditional loan approval. But I want you to also know that once you get past that deadline, just because that loan approval is indicating conditional does not mean you're going to be able to cancel this transaction if the buyer ultimately is not fully approved by that lender. All right. You're welcome, Kelly.
So not to beat the dead horse, but that loan approval, it has to be a full loan approval before the deadline.
No, conditional loan approval. It would be great if you
Conditional,
got a full loan approval. It is possible to get a full loan approval before your deadline. 100% possible. It is 100% possible.
but the
Um,
contract is not saying that you have to have a,
correct.
okay, that's where I have the confusion.
Correct. Contract is not saying that you have to have that. All
Okay.
right. All right. Paragraph 9. This is in your handout. You have this graphic that shows you what your who customarily selects a closing agent and pays for the closing costs, pays for the title search, the lien search, and the title policy. So there are 4 items as it relates to closing in paragraph 9 that matter or that are going to change based upon which paragraph you select, 9C1, 9C2, or 9C3, right? 9C1 is seller. So the counties that are in white are counties where customarily you're selecting 9C1. It is not the rule. Customarily, we select 9C1 in the counties that are in white. The counties that are in gold, 9C2 is the counties that are in gold. Actually, and this is an update. I just noticed this when I was preparing. In our updated graphic, this is gray. Dade and Broward are gray for 9C3. For the Miami-Dade Broward provision, these 2 counties are gray in our updated graphic because there's a split. For 9C1, sellers selecting the closing agent, pay for the title search, pay for the lien search, and pay for the owner's title policy. Buyers paying for the lender's title policy. In the counties that are gold, 9C2, buyer is selecting the closing agent, paying for the owner's policy, paying for the title search, paying for the lien search. In 9C3, Miami-Dade and Broward, these will be gray in our updated graphic. The buyer is choosing the closing agent, the buyer is paying for the owner's policy, but the seller is paying for the title search and the lien search. I call that split the baby. So you take those 4 items and you split it. Buyer is selecting the closing agent, paying for the owner's policy. Seller is paying for the title search and the lien search. All the other closing costs that you see laid out in paragraph 9 from lines 135 to 154, they're already broken out on each side. But what you see that's saying if 9C1 is selected, 9C2, that's what I just described to you. All right. Moving forward, because we're running out of time. All right. The last bit of paragraph, the last bit of the contract I want you guys to be clear on is paragraph 12. Paragraph 12, the inspection period. Make sure, I get this question still all the time. During the inspection period, the buyer can cancel for any reason whatsoever. Just because the sun does not, they tour the property at 10 a.m. They came back during the inspection period at 10:30, and what do you mean the sun is not the same as it is? The sun doesn't shine on the property at 10:30 the way that it shines on the property at 10 a.m. This won't work for me. I need to cancel. They can cancel. They can cancel for any reason during the inspection period. Any reason. Now similarly with that paragraph 11, I just want to call out this, the as is, because this has happened too. Doesn't happen very often, but if you're representing a seller, make sure the seller knows that the property has to remain in its as is condition. I think I mentioned this last week, meaning the pool can't be blue, grass green when you go into contract and you go to close and the pool is now green and the grass is black. You are in violation of paragraph 11, right? So make sure your seller knows that. Lastly, paragraph 19. When you are making your offer and reviewing an offer. Paragraph 19, look at it as an inventory. You shouldn't miss, you should not miss a necessary rider. Um, I don't know why they don't have the flood disclosure on this in this inventory. But we talked about that what, a week ago. You guys know that the flood disclosure is a required disclosure. But outside of that, all of your other disclosures and potential riders are listed there in paragraph 19. Take your time. Make sure that you look through each one and you select those that are apply to your transaction. Yes, it's being recorded. Yes, right? Do not tell me I didn't record this. This should be recorded. Yes, it's being recorded. Do not freak me out, Luke. Make sure that you look through and check the appropriate rider. Also, we talked about last week. Make sure you I recommend, it's not required, but I recommend that you use one of the compensation riders to make, if you represent the buyer, to make your compensation built into the contract. That was last week's discussion, right? All right. So that's paragraph 19. Lastly, QC check. You prepared your offer. Make sure there are no blanks. If it doesn't apply, for example, the home warranty, use NA. Make sure that you check the appropriate box where you have options. And then lastly, make sure that all of your attachments are included, your riders, right? Your disclosures. Make sure that they are included and that they are delivered and that they are included in your initial delivery. You don't want to get into a situation where you are piecemealing your contract package and now we're having a conversation about whether or not you in fact have a fully executed contract because you had let's see one of these riders. You had the HOA rider checked off, but it wasn't included with the offer. So now the seller has signed the contract, the offer. Now you have the seller has signed the offer, but you have a contract, but you're missing the rider, and the rider needs to be signed. So now are we having a conversation about do we have a fully executed contract? Or do we not? Because it showed that there should have been an HOA rider. This HOA rider was signed later. Make sure your entire package is together when the offer is sent. Make sure every document is executed and sent back. All right. All right. In your handout is a high level overview of what we talked about, right? We talked about the different entities, who has the authority to sign. We talked about personal property. This should jog you to make sure that you're clear on personal property. The washer and dryer standard. Of course, just a little reminder about the difference between the contract templates, the crisp versus the as is. The timing, right? Signature plus delivery is your effective date. 11:59 in the time zone where the property is located, right? Even in Florida, we have different time zones, right? We have the Panhandle, and then we have the Eastern Seaboard. So where's the property located? At it's the time zone where the property is located. Remember the financing contingency, and then just a little scenario for you when you are trying to remember when your effective date is. When was it delivered? All right. Questions. Let's talk about it. Let's talk about it. Let's talk about it. Ooh, we ran long. Only 25 slides. And we still ran
Can you
long.
go back to the last slide, please, Ms. Ricole, so I can take up? Yeah, thank you.
You should have, Musline, grab the handout. This is part of the handout. I mean, you can screenshot as well, but this is in the handout. PurchaseReadyLabHandout.com.
Okay, thank you.
No problem. PurchaseReadyLabHandout.com. All right.
Question.
Go ahead.
Is it okay regarding addenda and additional term? Is it okay to write in the additional term in lieu of having the writer? For example, like appraisal contingency, if you have the wording in the additional term stating, contract contingent to blah, 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 is that okay?
It's okay, but I would recommend you just use the writer.
The writer instead? Okay.
If you have a writer for something, I would use the writer. Because
Okay.
well, I would say why reinvent the wheel? Right?
Well, I see it very often that agent writes a bunch of things there instead of sending a writer. So,
But you're gonna work smarter, not harder. And you're gonna use the writer. If you have a built-in writer for it, use your writer. There's
okay.
no reason for you, potentially leaving out a term.
Okay.
So that's a very good question. That's a very good question. Jonquil, is this your question that you have in the chat? I see you got your hand up. You can ask your
Yes,
question.
I don't know if you'd be seeing it, so
I
that's why.
see it. Yes, they do not lose any of their earnest money deposit.
Okay, thank you.
The contract is canceled. Everyone goes back to status quo. Deborah's question on the corporation, who and how many have to sign a listing agreement? It's the same, either your VP or your president. You don't have to have all of them, right? Only one. In the prior class, I provided a compensation related clause to add to the contract. Cynthia, that's a whole class all by itself. Um, Technically, in addition, but we're using this writer. We're using these writers as some teeth. Last week we talked about the writers and what they I see your question, Brenda, and I'm smiling because like I didn't hit that. I usually always teach on that topic, but I didn't this time. But now I'm glad you asked that. So Ray Cole, keep that in your content. But going back to Cynthia. So Cynthia, last week we talked about the writers, and we talked about how the writers, writer FF and GG creates some congruency, some attachment between the buyer's compensation with the contract. The language that I provided with you guys, that I provided you guys, is last year is even more glue. It's even more glue because it fills the gaps that the writers have in the buyer's agent compensation. So for those of you who are like, what are you talking about, Ricole? So last week, just high level, last week we talked about ensuring that you utilize one of the writers to make the buyer agent compensation part of the contract. However, do understand, I'm not going to pull the wool over your eyes and have you think that that's all that's necessary. That's great. That's better than nothing. But do understand that the purchase and sale contract is between the buyer and the seller, not between the buyer, the seller, and the agent. So that means if some odd reason the buyer and the seller agree to change the terms of the contract to the extent that they say, well, we don't want to do, we're not doing the seller credit anymore for the buyer's agent compensation, you have nothing, you can't, if that's all you have, there's nothing you can do about that. The only thing you can do about that is now go after the buyer in court. based upon breach of the buyer brokerage agreement. I hate to end the call on that note, but you guys have to understand what these agreements mean, right? So that's what Cynthia is asking about. And again, um, for the purposes of everyday life, just make sure, if nothing else, use the writers, guys. Use the writers. We talked about the case where the brokerage did have to go after the buyer and sue them in court due to breach of the buyer's brokerage agreement. I will never pull the wool over your eyes. That is a real thing. It could happen. But to put some teeth in the deal to prevent you from having to go down that path, let's use a writer. Okay? All right, Brenda's question. How do I feel about honor before? I do not agree with honor before. I always teach you guys, put a date. The parties can always agree to close sooner, later. But when you put honor before, if we're going to go into contract today, today's the first, and you say honor before the 30th, what is the before? Is it the 5th? Is it the 7th? Is it the 10th? Is it the 9th? Right? That's why I do not agree with honor before. And I've had agents tell me that their brokers do not allow honor before. You put a date and then you can always agree to close sooner. Because it has happened where one of the parties was looking at the before, whereas the other was looking at the on. Okay? Lugness question. Why pay title insurance to pay owner's policy in Broward if the buyer chooses title? In Broward, let's look at it really quickly. Let's go ahead and read it. If you select 9C3, it specifically says buyer should designate the closing agent and pay for premiums for owner's title policy. So that's why they're paying, because they agreed to it. The contract specifically says that's what when you select 9C3, buyers selecting the closing agent, buyers paying for the owner's policy. Sellers paying for the title commitment and the lien search. All right. Let me know if that doesn't answer your question, listener. Tabitha's question: if loan approval is April 1st, loan approval deadline, I'm assuming is April 1st, and appraisal hasn't come in yet, I will get a conditional approval per the lender, but will need to add an extension for appraisal. I doubt you'll even get a conditional approval if you don't have an appraisal yet, Tabitha. That's a very good question. I would never, as a loan officer, as a lender, I would never give you a conditional approval. That makes no sense. Like, the appraisal is so much part and parcel with the approval that why would I even give you a conditional approval? Right? But that's a good question. So the answer to your question is you are absolutely you're getting an extension of the loan approval deadline altogether. You're not even getting a conditional approval. Very good question. Very good question. Deborah, you asked the question on selling a property in a corporation, how many have to sign the contract to sell and again sign at closing? Just one. Just one. Just one. Let's go back really quickly. Let's go back really quickly. If you look at the handout, tell you the VP of the president. All right, there you go. No more questions? Cool. Guys, no training next week. Blasphemy. No training next week. On vacation next week, April 9th. However, we will be in the following week. Our 4-part series, Essential Closing Skills for Florida Realtors. You guys got to know how to block, stand in the paint. When it gets to closing, everybody's like, they're telling me I have to do this. No, you don't, right? You guys got to know how to get in the paint and get your deals to closing without being pushed around, right? Pushed around by other agents, being pushed around by your clients. Let's get some clarity around what happens at closing. All right. All right. So we're going to start that not next week, but the week after. All right. Thanks, Cynthia. Marceline, good to see you again. Good to see you. We got some Camilla, good to see you again. We got some returning guests. Not guests, returning family. All right, guys. Remember, If you are not receiving text message reminders, make sure to sign up for the reminders. All right. All right. All right, guys. Oh, so glad. Good to see you guys.